The next item, also for information, because I know many of us have heard much of this before, but it needs to be stated in public, and we'll have some questions and comments in the same limited way, is the report of the Equity and Aboriginal Issues Committee and the challenges faced by racialized licensees' final report. Ms. Leeper.
Thank you, Treasurer. The report, if anyone wishes to have it in front of them, is at page 232 of board books in today's agenda. Treasurer, lawyers, and paralegals have a special responsibility to uphold human rights principles, protect the dignity of individuals in society, and recognize diversity and inclusion. Le barreau s'est engagé à maintenir une profession qui tienne compte de toute la population de l'Ontario de manière inclusive et libre de discrimination et de harcèlement. 4 years ago, as part of its public interest mandate, the Law Society of Upper Canada struck a working group to investigate the challenges faced by racialized lawyers and paralegals, and to consider strategies for enhanced inclusion at all career stages. So beginning in 2012, the working group engaged in extensive research as part of this mandate. We began by gathering information through surveys, focus groups, interviews, and meetings. And from there, we moved to a consultation process across the province and carefully considered the information collected to develop the recommendations that you see in today's report for information. Convocation has been involved at certain interim steps along the way. You approved our consultation plan in 2014 and received a status report in April of 2015. The recommendations stem from the working group's recognition that the problem of systemic discrimination within the legal professions is real and significant. Racialization is a significant factor that shapes the careers of legal professionals beginning in law school. Voici quelques points clés de groupe de travail. Over 1/3 of paralegals and 18% of lawyers identify as racialized. La discrimination est une réalité quotidienne pour de nombreux titulaires de permis racialisés. For many racialized licensees, discrimination is a feature of everyday life. 40% of racialized licensees identified ethnic or racial identity as a barrier to entry into practice. And in contrast, 3% of non-racialized licensees identified ethnic or racial identity as a barrier. More than 50% of the survey respondents said they were expected to perform to higher standards because of racial stereotyping. In the community liaison process, we heard from many that racialized licensees felt they had to work twice as hard to obtain the same amount of respect as a non-racialized licensee. De nombreux titulaires de permis racialisés ont besoin d'un solide réseau de professionnels juridiques, de mentors ou de parraineurs qui puissent leur fournir des conseils et un soutien dans leur lieu de travail, et ce manquer peut poser un obstacle durant leur carrière. Our best work as professionals is fostered when we work in inclusive, supportive workplaces. We do better when there are policies and measures aimed at creating a larger sense of belonging and an interest in the potential of all who work there. And we are better able to serve the needs of our communities and do justice. We're more creative and open. Access to justice, the quality of legal service, and the reputation of the Ontario legal system all demand a response because of the role that lawyers and paralegals play in society. So as such, this report is all about the public interest. During all of the consultations across Ontario in many legal practice settings, from small to large firms, organizations and associations, we heard that the Law Society has an important role to play. Systemic problems demand systemic solutions. And we heard that the profession is ready to embrace this. There are many champions. There are affinity organizations, the in-house council who created Legal Leaders for Diversity, the law firm Diversity and Inclusion Network. These are signs of change. Some firms have begun to train their recruiting teams on matters of unconscious bias. And others have begun to ask themselves whether they are unwittingly creating barriers to advancement for some members of their firms. We commend this work. There is much more to be done. And we have a role to play in accelerating change, providing guidance, coordinating effort, and educating broadly about these issues across the professions. The working group responsible for this report is made up of elected and appointed benchers from diverse practice areas and personal backgrounds. As you know, we deliberated for months on these recommendations and considered multiple perspectives. We learned from the bar, from each other, and we were exceptionally well served by the tireless and committed work of Policy Council Ikua Kwanzaa, quality of input from senior management coordinated by Grant Wedge, and the leadership of Jose Bouchard, former Director of Equity, Alison Chiron, Acting Director of Equity, and now Marion McGregor, our Equity Advisor. I wish to acknowledge my co-chair, Raj Anand, Vice Chairs Julian Faulkner and Howard Goldblatt, and the entire working group with gratitude and admiration. We embrace the task of developing meaningful and responsive policy responses to a challenging issue with the support of the entire group. Nobody gave up on the project, even when it was not always clear that we would land on a final report. So to all of you, thank you for showing what Mei Cheng described at yesterday's panel on women and diversity as grit. And we are all looking forward to continuing the conversation over the next few months until December, when we will return with these recommendations for you to consider. So the culmination of the work, the study, and the consultation, Working Together for Change, is our report with 13 recommendations to address issues of systemic racism across the legal professions. The recommendations seek to accelerate culture shift towards eliminating barriers, achieving inclusive legal workplaces, and fostering the talent and excellence within the legal professions in Ontario. As you know, it's for your information, and it is thus now a public document. We will be inviting comment from the profession and returning in December, as I say, for approval. I'm not going to read through the recommendations, you can read them, but they can be understood as falling into 6 general categories. First, recommendations 1 and 12 look at strengthening our rules and processes for dealing with complaints of discrimination. Recommendations 2, 3, and 8 speak to requiring the acknowledgement and adoption of principles and policies and providing support for the creation of policies and resources for firms. Recommendations 9 and 10 speak to education of the professions about their obligations, starting with the licensing process and moving forward through practice. Recommendation 11 addresses support and mentorship. And recommendations 4, 5, 6, and 7 discuss a variety of ways to measure and share meaningful information with the professions, with firms, and on our progress as a whole. Finally, recommendation 13, leading by example, refers to the Law Society, both at the staff level and here in this room. So at the heart of the recommendations are 3 objectives that we began with when we drafted this report, and you'll see those in the executive summary. And they are to foster the development of inclusive legal workplaces in Ontario, to reduce the barriers for hiring and advancement created by racism, unconscious bias, and discrimination, and to work towards a better representation of racialized licensees at all levels and seniority across the professions. Each of these recommendations are discussed within the body of the report, and we anticipate that approval will require a number of implementation pieces, including bylaw amendments, investment in information technology to record and analyze progress, and that would be done through a senior staff implementation working group. So I will conclude. Thank you, Treasurer, for the time to do this. The measures do strive to reduce discrimination and ensure that the wealth of talent across the professions is appreciated and deployed at all career stages. A thriving profession is capable of serving a diverse population. We invite members of Convocation to consider what we are proposing, to engage with the communities who have been patiently awaiting this stage of our work, and take an interest on how we can all work together towards solving this problem. Thank you.
Thank you very much, Ms. Luca. So again, as I said, this is for information. This will be debated fully, I'm sure, in December. But again, I'm prepared to open the floor for limited comments, questions around process and going forward. And I see a number of hands up, but Mr. Anand is already on his feet.
Mr. Anand and I are going to take questions together because we worked on this together.
All right. So Mr. Faulkner first.
Treasurer, through you to my fellow co-chairs and fellow vice chair, Mr. Goldblatt and committee members of the challenges faced by racialized licensees. This process has been a long one, and we identify dates, but sometimes we don't stop and pause. Some will say 4 years to get to this stage. Now you want months to discuss it. I just, as a process issue, want to raise this for everyone's consideration, Treasurer. And I speak as a biracial lawyer who for over 25 years have seen these issues land in my lap in one way or another. It has been decades, if not centuries, that we have grappled with issues of racism in Canadian society. That it has taken us 4 years to name the problem and to start talking solutions should hardly be a great surprise. It is a reality that there is no magic bullet. The committee, as diverse as it was, struggled but worked hard. I want to address two issues very quickly, Treasurer. Firstly, how important it is to Canadian society that we be fearless in identifying the problem. An African-American novelist by the name of James Baldwin, who was recently recognized actually in the last days at TIFF, that is a documentary about him, stated the following: "Not everything that is faced can be changed, but nothing can be changed until it is faced." The reality of using the term systemic racism in the title of this report and in the report is all about our ability as a profession to come to terms with the dialogue and to be respectful about the dialogue and to name it for what it is. I can't emphasize enough how important that is in this process over the next 4 months, but I want to say something that we should hardly be congratulating ourselves for being groundbreakers. Chief Justice McMurtry, prior to Chief Justice McLaughlin, in a case called Wilson, spoke of the evil of racism that went across, as he put it, beyond metropolitan Toronto, across this province. Page 8 of the judgment for those who want to look. Chief Justice McLaughlin in Williams spoke about systemic discrimination and racism that permeates the criminal justice system. She was speaking about Indigenous peoples, but if you want to read her views on racism and naming the problem, simply look at her 2002 article, in which she titles her article, "Racism in the Law." We need to talk about the problem, be blunt about its existence, and at the end of the day, be willing to take on the challenge. This is only a beginning. To those who might be skeptical about how conservative this report is, I have this to say. There always must be a first step to any solution. This is an important first step. To those who feel the first step is too far, it has been a long time coming that we recognize we need to create a healthy work environment for all of our colleagues. Treasurer, I'm very proud of our executive and very proud of our committee, and I thank you for allowing me these few minutes to speak.
Thank you, Mr. Faulkner. Ms. Esprey.
An actual question, Treasurer. I believe that it's important to our decision-making process for us to understand the impact of our decisions, or the potential impact of our decisions. I'm reminded of the time before I was a bencher, which strangely seems much longer ago than it was, when I was watching with much interest the process of the of Convocation in addressing the matter of Trinity Western. And one of the things that happened in that instance was that there was, in fact, some information from outside counsel about the responsibilities of Convocation and the powers of Convocation. And I have a few concerns with some of the recommendations. Not that I don't like them. I have concerns about, as said, their potential impact and potential charter impact in terms of requiring people to think certain ways, which I don't think we can actually do. And also, as we currently have no authority to regulate workplaces or legal firms, it's something I know that we're discussing, but it doesn't exist yet. And as such, when recommendations 3.4, recommendation 4, and other recommendations mention interacting as a regulator with workplaces, that seems like it could be ultra vires for our society as it stands. I would hope or appreciate that before our decision-making process in December, we could get, or we could request an opinion from Law Society Council, although I suspect that Elliot will hate me for that, or an opinion from outside counsel regarding the charter and other impacts of these recommendations. Thank you.
Mr. Anand?
I thank Ms. Vestry for the question, and I just wanted to address it very quickly. First of all, in terms of legal authority, the legal authority of the Law Society in relation to these human rights issues was considered at all stages of the process. With respect to the points that Ms. Vestry raises, which are about the interaction between, I take it, free speech and human rights obligations, these are issues which have been tested many times in the courts and in which the human rights codes and their validity have been upheld. With respect to all of the recommendations, as I think is indicated in the report, other than the issue of coverage of non-law firms, if I can put it that way, an issue of coverage of in-house lawyers and government lawyers, with that exception in which you have the significant majority view and there was a minority view, but with respect to the 13 recommendations as a whole, those were unanimous. The working group of 15 ventures was unanimous in taking these views. Now, with respect to implementation issues, of course we have to be conscious of the legal authority of the Law Society, and I think as in all measures passed as a matter of policy by Convocation, in their implementation, we have to be conscious of both operational issues and legal authority issues, and there's no doubt that that our staff will be continuing to be aware of those issues as we go forward.
Thank you. Ms. Ross?
Thank you, Treasurer. As of tomorrow, when our 2 articling students are called to the bar, our firm will be a firm of 9 lawyers, 5 women and 4 men. We are at the 55% club, not the 30% club, I'm proud to say. But I noted, and I asked the question at the information session on the report, recommendation number 3, that the requirements in 3.2 and 3.3 have a cutoff of 10 licensees or more. And as a firm of 9 lawyers, we will not be subject to the requirements of recommendation number 3, and I asked why not. My understanding of the statistics of law firms in Ontario is that those of us who are members of firms of 9 or fewer comprise at least 50% of the law firms in Ontario. And therefore, and I asked at the information session, if we're 50% of the law firms, we must also, by necessity, be 50% of part of this problem. So why are we excluded from the implementation of the on-the-ground policies in our workplace by virtue of a 10 licensee or greater requirement? That concerns me greatly. And quite frankly, I'm distressed that my firm will not be subject to these recommendations, and ask the members of the committee, as I did at the information session, for their reasoning around this. I assume as well that this should not be problematic, given that we are headed for compliance-based entity regulation. This is the very first type of compliance we should all be required to comport to.
Thank you, Ms. Ross. Ms. Leeper?
Yes, thank you, Ms. Ross, for the question. You will see that some of the recommendations are universal. For example, recommendation number 1, the CPD requirement, and any firm could participate in the project that is proposed to bring forward templates and draft model policies. However, the working group chose certain firm sizes because we were thinking of regulatory burden at this stage in terms of legal workplaces that would be subject to some of the mandatory measures. Not an exact science to be sure, and this is the kind of policy that we could foresee changing as we get more data. The other part of this is regular measurement using the same kinds of questions that we asked at the very beginning to see what is happening around the profession. And of course, it need not be something that is so rigid that it could not change, especially if we started to get different information about where barriers continue to persist. So I thank you for the question, and those are the considerations that we apply.
Mr. Callahan?
First, let me commend the working group for their hard work in this really important initiative. I rise for 2 reasons. One, I support Ms. Vespry's concerns, and I think that she's absolutely correct. And the comforting words of Mr. Anand don't satisfy me. So I too would like to see something, and I would also like to consider whether or not, when we go to vote these things, that those issues can be dealt with separately. Because if those of us do not accept we have the authority to do certain elements here, we ought not to do them. So it is an important issue, and I thank Ms. Vespry for raising it. The second is a question, which is, when I read the report, I have a little bit of uncertainty as to whether we have an issue with respect to those who are prepared to enter our profession. The report refers to our racialized lawyers going from 9 to 18%, and that currently racialized persons who identify in the province as racialized is somewhere in the 25%, perhaps. What I wouldn't mind knowing is whether the working group sees us having a problem attracting racialized lawyers, racialized people to the law. That would mean having an understanding of not what the average is, but rather what the demographic would be in the last 3 to 5 years of entrance, I would think, and whether or not we've identified certain racialized groups who are really disadvantaged as to entering the law. And I appreciate what you're doing is to make sure everybody gets a fair shake, and I think you're absolutely correct in doing so when they enter the law. But if the profession doesn't look like them from the start, it's never going to look like them at the end. And the report didn't really help me understand where we are today.
So I think that those 2 points are ones that we will certainly take back to the committee. And again, we're grateful for an opportunity now and in the next month or so to hear from benchers if they want more information about certain aspects of demographic profile, the questions that have been raised about legal authority, and we will be prepared to answer those in December.
Okay, thank you very much. Are there any other questions in the same vein of clarification or process in the room?
The conference is no longer in lecture mode.
Any on the phone? Hearing silence? Beg your pardon?
No, I said it's fine. Thank you. Very good report. I appreciate it.
Thank you very much. Okay, well, that's it then. Thank you very much, and may I just echo the comments as well that have been made to thank the group and its leaders for the very long and hard work that they've done on this, and it's clearly not quite over yet, and we look forward to the debate. I look forward to the debate in December. We will take the morning break for 20 minutes. Thank you.